afternoon, everyone, and welcome to the latest in our series of webinars with our legal partner, A&L Goodbody. We're really thankful to A&L Goodbody for their time and expertise, and we're delighted to make a return to this series for the first legal webinar of 2023. Clearly, the series is striking a chord with members, as the numbers signing up for this and others have been really strong, and they have continued the same vein into 2023. For anyone who does want to catch up on the previous webinars in the series with A&L Goodbody, you can do so on our website, charteredaccountants.ie/Ulster. So for today's webinar, we have David Rowan and Anna Cartwright with a look at recent developments and trends in the area of directors' responsibilities. They will also be providing an update on other key legal areas which directors should be considering. David is a partner in A&L Goodbody's corporate and M&A group in Belfast. He is a very experienced corporate and commercial lawyer with a focus on public and private mergers and acquisitions, leveraged and managed buyouts, group reorganisations, strategic investments, venture capital investments, and the list goes on. Anna is a senior associate with A&L Goodbody here in Belfast. She specialises in corporate, transactional and commercial advice. She has advised on a wide range of transactions at a local, national and multi-jurisdictional level, and has acted for a business in a variety of sectors, including retail, manufacturing, food production, sports, healthcare, leisure, technology and IT. So there are certainly plenty of strings to Anna's bow from a sector expertise perspective. As usual, please feel free to put your questions for our presenters into the question and answer box at the bottom of your screen. It is open now, so feel free if you have any in advance before they even get started. As usual, I would ask you to please keep the questions general. David and Anna can't answer anything specific in terms of legal queries during the webinar, but we can share their contact details after should you wish to contact them directly to get more detail. We have a lot to get through this afternoon, so David and Anna will be a bit of a double act this afternoon. They will present for in around 40 minutes, and as I say, there will be time for questions after. So let's get started, and I'd like to welcome David and Anna.
Good afternoon, everyone. Hope you can hear me okay. If there are any issues, please just put it into the chat, and we can take any technical changes that may be required. So thank you very much, Emma. As mentioned, I'm David Rowan. I'm a partner in the corporate team here at A&L Goodbody, and my colleague Anna Cartwright is a senior associate here in the corporate team. And today we're going to talk and present on directors' duties. It's a topic a lot of you will be familiar with from previous presentations, and obviously during day-to-day interactions with the businesses that you are advising and working in. We're also going to cover probably the legal framework around those, what the duties actually are, but we'll then move on to some of the hot topics or current areas in which we are receiving queries from clients, just given the various economic headwinds and wider economic position that we find ourselves in today. As Emma mentioned, we're probably going to talk for 35 to 40 minutes. All questions are welcome. It's a topic that I think is relevant. It'll be relevant for both those of you who are in businesses on boards, but also those who are advising companies as well. So without further ado, we'll get going. And as I say, if you do have queries, please do raise them in the chat function, and we're happy to answer those at the end. So Anna, over to you.
Thank you. Good afternoon, everyone. So to set the scene, firstly, we will be considering the question of who is a director. We'll then briefly discuss the role of the board before moving on to the duties themselves. And when we do so, we'll consider where do they come from, who are they owed to, what are they, and what happens if you breach them. We'll also include a couple of pointers on practical steps that you or your clients can take to ensure that you remain on the right side of things. So on to who is a director. It's defined in UK company law as any person acting as a director by whatever name called. And there are largely 4 categories of directors. We have executive directors, non-executive directors, de facto directors, and shadow directors. UK company law doesn't distinguish between executive and non-executive directors, and they are known as de jure directors. They're subject to the same legal duties under the Companies Act, and company law also extends duties and obligations to de facto and shadow directors. So we'll briefly take each of these categories in turn, starting with executive directors. These are your officially appointed directors, the people whose names you'll see appearing on the company's file at Companies House. They're typically employed full-time and they manage the day-to-day business of the company. Non-executive directors, on the other hand, aren't involved in the day-to-day business. They're usually employed or engaged on a part-time basis, and usually they're appointed because they have a particular skill set or sectorial insight that they can bring to the company. NEDs play also a very important role within a company's board in that they can bring an independent insight to the company, and when appropriate, they can constructively challenge the board. De facto directors are those who, whilst not validly or officially appointed as a director, act as though they are a director. There's no definitive test for what constitutes a de facto director. Someone might hold themselves out as being a director, the company might hold them out as being a director, but that's not in and of itself decisive. What is important is the question as to whether are they carrying out roles or functions which should properly only be done by an officially appointed director. And if someone's held to be a de facto director, the implications of that are that they're held to the same legal duties as our de jure directors. Lastly, shadow directors. And this is a person in accordance with whose instructions or directions the company is accustomed with acting. So the purpose of this definition within the legislation is to capture those people that have a real significant influence over the direction and affairs of the company, aside from its professional advisors. If someone's held to be a shadow director, then the duties and obligations can also extend to them.
Yeah, and I think I'd just add that the final sort of type of director, which some of you will obviously be familiar with, is an alternate director. So again, this is a director that's appointed in absence of or an individual appointed in absence of a director, and just worth noting that as a practical point, it's always useful to have provisions around appointment of alternate directors in a company's articles. It's also worth noting that an alternate's duties are the same as a director, that an alternate is able to vote on the matters concerned, and that an alternate sort of should effectively follow the same process around decision making with regards to taking decisions that are in the best interests of the company. But useful sort of workaround to the extent people may or may not be available, and obviously very helpful with regards to that the SME market here in Northern Ireland, where boards are varying sizes and degrees of experience.
Thanks, David. Moving on then to the role of the board of directors, and you'll see that we've identified what we see as 4 of the key functions of a board. The board obviously is responsible for establishing the strategic direction of a company, including evaluating present and future opportunities and risks, and also for determining the company's values. The board is responsible for the management of the business of the company, and this is wide-ranging and includes approval of significant transactions, delegating functions and responsibilities to the wider management team, and also then an important one is oversight. The board's obviously responsible for monitoring the performance and financial condition of a company. Lastly, then we have responsibility, and what we mean here is accountability to stakeholders. So understanding what the stakeholders' interests are, and ensuring effective communication both ways. Key question, I suppose, for today is, why should you or your client care about directors' duties? And the purpose of this slide really is to focus the mind. We are conscious that this can be often a dry enough topic, but it is an important one. When someone accepts the role of a director, they're accepting a really significant responsibility. And if things go wrong, there are consequences not only for the company, but also for the director personally. We've identified 4 headline issues there of why you should care. The company's fortunes are tied to the decisions that the board makes. There's reputational damage, potentially, if things go wrong, not just for the company, but for the directors themselves. There's also the possibility of criminal convictions and personal liability. So the better informed you are, the easier it is to avoid the pitfalls. And later we will discuss some of the practical steps that you or your clients can take to try and stay on the right side of things. So today we are focusing primarily on the duties which are codified in the Companies Act, but it is important to bear in mind that there's a wider framework at play here. Before the duties were codified in the Companies Act, they were derived from case law and common law, and this remains relevant when it comes to the interpretation of the statutory duties. And also there are some duties which haven't been codified in the Companies Act, but which still apply. Then at an industry and sort of sector level, there are obviously other laws, regulations and guidelines which apply. So as I say, a wider framework is at play here, but today our primary focus will be on the Companies Act duties. Now to the question of who are the duties owed to. The general rule is that the directors owe the duties to the company, but there are sort of important expansions on this. Directors must have regard to the interests of shareholders at all times when making decisions. There are circumstances where the interests of employees must be balanced. And when it comes to the zone of insolvency, the interest of creditors sometimes replace the interest of shareholders. And we will discuss a really interesting recent Supreme Court decision about that particular issue later on in the presentation. And I'll hand over to David now to sort of discuss what the duties actually are.
Thanks, Anna. So yeah, as Anna mentioned, there are various sources of duties for directors, and probably the primary focus for us today are those that are actually set out and codified within the Companies Act. Again, the phraseology of the wording up here on the screen is probably something you'll all be familiar with, but I think it's always worth a reminder, and always worth looking behind what the actual duty says on its face to see what are they getting at, what does that mean, what does it mean in practice, what am I supposed to be thinking about, or what am I supposed to be advising my clients about when I'm around a board table or in receipt of a board pack, and I'm trying to figure out what my decision, what my independent judgment will be. So the first one up here, duty to act within your powers. Again, look, it's a very obvious one. A company's constitution, its articles of association, potentially other documents sitting behind that, such as shareholders' resolutions and any shareholders' agreement, will set out the powers that are delegated to the directors to run the business. It's important that directors stay within the scope of those powers. To the extent they act outside of those powers, it will have an impact on the enforceability and effect of some of those actions taken. And depending what actions those are, but there could also be an adverse effect for the director concerned. So pretty obvious, pretty basic, but let's understand the scope of your powers and stay within them. Similarly, if you're an advisor and you're being asked to comment, it's about looking at the documentation sitting behind it, and understanding and ensuring that your advice is to enable the directors to act within that scope. Second one is one that's pretty often cited. So the duty to promote the success of the company, that together with the duty in section 174 to exercise reasonable care, skill and diligence are probably the two that are most cited when looking to either challenge or bring a bit of rigor to directors' decision making. So in terms of where to unpack the duty to promote the success of the company, the starting point is usually looking at what success is, and that's really for the members or shareholders to decide. But typically, it's taking decisions that are going to promote the growth, both in terms of revenue and profile and in value for most companies. The duty has sort of two limbs. Acting in the way that the director considers will promote the success, but in doing so, they need to have regard to a number of factors. I'm going to read these out, but it is worth just sort of contemplating and thinking about them. So one is likely consequences of any decision in the long term. It's not just a short-term immediate impact. Then you have the interests of the company's employees, the need to foster the company's business relationships with suppliers, customers, and others. The impact of the company's operations on the community and the environment. Desirability of the company maintaining a reputation for high standards of business conduct, and the need to act fairly as between members of the company. So again, you can see there are a number of considerations, there are a number of limbs to it. And I suppose for those who are sort of familiar with the more modern and more recent topics around ESG, there are a couple of interesting references there to the company's employees, the community, the environment, and the longer term sort of sustainable element to that. So it's working its way in as a consideration and something that directors need to think about. Duty to exercise independent judgment effectively does what it says on the tin. Directors mustn't allow their personal interests to interfere. To the extent they are appointed by a particular stakeholder, such as a shareholder, the directors are able to have regard to that shareholder's position. But the key is that they still must act in accordance with the best interests of the company, and they still have to apply that independent judgment. Same for directors who are receiving advice from accountants or lawyers or other professional advisors. They are to have due regard to that advice, but they can't blindly follow it. They do have to apply their own independent judgment. They do have to review it. They do have to apply it to the particular business, particular set of facts at hand. And they do have to make sure that ultimately the decision they take reflects their independent judgment. With regards to the duty to exercise reasonable care, skill, and diligence, section 174 of the Companies Act, there's effectively two different tests here, the objective test and then the subjective test. So again, the general care, skill, and diligence that would be reasonably expected of a person with the experience and in a position of the director is pretty well settled. But the subjective test is one that may be of particular relevance for today's audience. So the general knowledge, skill, and experience of a specific director will also be factored in certain circumstances, and that's relevant. So, for example, where an accountant was on a board as a director, and particularly on matters that would be reasonably considered to be within your area of expertise, then there would be a slightly higher subjective test there to be met compared to just a reasonable director with a broader range of experience rather than a specific expertise. With regards to the duty to avoid conflicts of interest, directors are required to avoid situations where they are acting in conflict with the company. This is separate and distinct from a transaction in which a director has an interest. So it actually has to conflict with the company. And typically, the best ways of dealing with this issue are to be very clear about what interests a director has, make sure those interests are disclosed, and look at any procedures within the company's articles of association around what requirements there are to either authorize to enable the director to vote, or to enable the board to vote on matters without that director being able to vote, so effectively standing aside while certain decisions are taken. So I think that the key practical piece there is continually updating registers of interest and ensuring that disclosures are made that may result in potential conflicts of interest. Duty not to accept benefits from third parties, again, fairly obvious. There is no de minimis threshold. There's no breach if it can't be regarded as reasonably giving rise to a conflict of interest. So there is scope there, but again, it's ensuring that they're not receiving a benefit from a third party, which will result in certain decisions being taken, which may or may not be in the best interests of the company and promoting its success. And then lastly, sections 177, 182 taken together are duty to declare an interest in a proposed transaction or arrangement, or a duty to declare an interest in an existing transaction or arrangement. So again, similar to the conflicts of interest, key point here is to maintain a register of interests, to ensure that register is continually updated, to ensure that there is as full and complete a disclosure as possible as to what that interest is, and then also just again to ensure that the process set out in an set of articles of association or shareholders agreement or other constitutional documents are followed very, very closely to the letter, to ensure that there is no breach of any disclosure obligation. Typically, where an interest is declared, the relevant director will still be able to vote in the matter. And as I say, a lot of the times in terms of practical questions that we get, it's this question of, is it a conflict of interest, or is it simply just a declaration of an interest? Are you conflicting with the interests of the company, or is it simply an ancillary or indirectly related matter in which the director can then continue to vote, or does he have to excuse himself? So that's sort of where a brief kind of overview of the duties that are codified and sort of sets the framework within which directors have to operate. The next point actually we wanted to cover is how long are these duties owed for, and you'll see there that there's been reasonably recent case that has changed this. So typically with most directors' duties, they start and end when a director starts in office and ends when he or she ceases to be in office. There are exceptions. One is the duty to avoid conflict of interest, and the other is the duty to accept benefits from third parties. Both are tied back to information that the director became aware of when he was acting as a director for a particular business. We put up on screen there, I suppose, a very brief summary of the case of Burnell versus TransTag Limited. This is new law. It was considering the codified provisions in the Companies Act probably for the first time, and has extended the period during which these duties are owed to a particular business beyond the director ceasing to hold office. So again, I'd urge a degree of caution around this. I think every case will rise and fall on its own particular merits. In this case, Mr. Burnell wasn't actually a director of TransTag Limited. He was acting as if he was, so he's held to be a de facto director. He then left quite abruptly and became a shareholder and director in a competing business. TransTag Limited proceeded to collapse shortly after that, and it was held that he was actually in breach of his duties to avoid conflicts of interest, because he went across to a competitor with confidential information that he had clearly obtained during his role as a de facto director in TransTag. And I think personally that case is limited to the pretty strong conflict that was there. I'm not sure it would be decided in every instance, but I think it's a really important case to flag to your clients or individuals who may approach you for advice, that they need to be very careful as to their actions after they leave a business. It's not only restrictive covenants and their contracts that they may need to be aware of, but also they just need to be very close that they're not in breach of these directors' duties, which will extend beyond the termination of their office. And then we thought it would be useful just to sort of set out some of the consequences of a breach of directors' duties. So there's a huge range here. It'll depend on the circumstances. It'll depend on the individual breach. But you know, again, this slide is sort of the so what. This is why it's important. So there's a whole range of directors could be liable to pay damages, compensate the company, any transaction, related party transaction, for example, could be set aside. Could be restitution for improper profits. The company's property could be restored. There could be an injunction, depending on the timeline around what the breach is, if it's happened, if it's capable of being prevented. There will be a costs impact. That could be a cost for the company or the director personally, depending on the specific breach. There's likely to be a termination of a service contract or disqualification from acting as a director, depending on the circumstances. Again, sort of wrongful trading, fraudulent trading, etc., would lead itself to disqualification. Reputational damage, as Anna has already alluded to, for both the company and the business. And then in the case of a breach of Section 182, so again, that is the requirement to disclose your interest, then there could be criminal penalties involved in that. So there is a whole range. It will very much depend on the specific actions, but it is important to factor all of it in and then apply it to the particular set of circumstances that you may be asked to advise on, or you may be involved in discussing if you're sort of sitting on a board yourselves.
Thanks, David. So now that we've heard what can happen if you do breach directors' duties, we thought it would be timely to offer a few practical suggestions and steps that you can take to try and mitigate those risks. So it goes without saying, understand your role and your duties and what that encompasses. Ensure that new directors receive training when they come on board and that that's a continuous process. You'll want to keep up with developments affecting the company and ensure that all relevant information is provided to you. And if it's not, you should be asking for it. You should also reflect on your duties whenever you're implementing company strategy, setting company strategy, and so on. Attend board meetings, again, that goes without saying, but ensure also that you're well prepared. You read the board packs in advance. And when material decisions are taken in those board meetings, ensure that that's properly documented, and show evidence that you've considered your director's duties, you've balanced the interests of stakeholders, and so on. You might also want to consider directors' and officers' liability insurance. This certainly has its uses, but it is important to note that it won't cover instances of fraud, dishonesty, willful default, or any criminal behaviour. And last but not least, if you do find yourself in a situation where you're not sure what to do, seek independent professional advice and seek it early. So now we will move on to discuss some of the hot topics in this area, and I'll hand over to David in that regard.
Thanks. So, yeah, I think when we're asked to look at recent developments or hot topics, things we're being asked to advise on, or areas of concern for clients, be they the companies themselves or individual directors, that there is a whole range, but we thought it might be useful for those on the seminar or attending the seminar remotely today, just to run through I suppose, A, some developments, but B, some of the issues that we're sort of seeing in the round. As Emma mentioned, we probably can't discuss specific circumstances, but I'm sure a lot of this will be familiar to those on the call. I think as the lights go out on us here, sorry, 1 second. There we go. One area that we're getting a lot of queries in, and I think will continue to be an area which is relevant over the next 12 to 18 months in particular, is this area of who directors owe their duties to, particularly where there are solvency concerns or performance concerns in relation to the company that they are directors of. So I'm sure this is an area that a number of you have been asked to advise on or are involved in currently, just given the economic climate that we're in. It's as Anna mentioned at the outset, directors' duties are typically owed to the company, save where there are solvency issues and you enter this so-called zone of insolvency, in which case the directors' duties can flip and be owed to the creditors of a company. That's an area that we are asked to advise on a lot, but I think the point we'd like to get across here is it is actually a developing area of law still. So we'd be advising clients to seek advice from accountants or legal advisors as early as possible in the process so they can be guided along that route. It's important in a practical sense for clients to document their decision making if they do have any concerns around this, and it's important to make sure they're taking relevant advice and sort of cash flow forecasts and looking ahead as much as possible. But this particular case is interesting for lawyers because it's a decision of the Supreme Court, so the highest court that we have in terms of looking at the nature and scope of directors' duties. The zone of insolvency, it's always a difficult piece of advice as to, directors will think they can trade their way out of it. And I think you need to be very, very careful. This decision probably reassures directors in this regard because it's actually a decision with regards to a dividend that was paid to a parent company at a time where the subsidiary was solvent. There was no risk of insolvency on the horizon in the short term, but there was a potential risk of a pollution-related liability that could arise in the future. So lo and behold, dividend was paid, parent received the dividend. Around 10 years later, the potential liability crystallized, and the question came back to whether this dividend should have been paid. And I think to give the real benefit for directors around this decision is that it does give some clarity as to what considerations they should be thinking about, and at what time, what's the relevant time for making those decisions. So it's about the position as it is when they're currently taking any decision to distribute assets or make a dividend payment. It was held that a real risk of insolvency is not enough to trigger the duty to creditors. So it almost essentially needs to be inevitable that there's going to be an insolvency process before the duty will trip over to being a duty to creditors, and a sort of a real risk of a future liability is arguably not enough to trigger this. So the company must be actually or imminently insolvent, or insolvency must be probable. So that is quite a strong test, and I think does offer more protection than maybe directors and practitioners might have thought they would have had. But I think again, it is fact specific. It's very much dependent on a specific set of facts in a case, and it is a developing area of law. But it's a decision of the Supreme Court. It does give clarity and an interesting discussion to a lot of these topics, and it's something that I think will assist boards and advisors in advising this area.
So this is something that we really at this stage just wanted to put on your radar, I suppose. It's a piece of legislation which is currently in bill form at the moment. It's going through the House of Lords. And why it's relevant and why it matters, I suppose, is that as accountants, a lot of you will be dealing on a regular basis with Companies House. And part of this bill is proposals to reform Companies House on quite a significant basis. The context to it is that it follows on from another piece of legislation which was enacted last year, the Economic Crime, Transparency and Enforcement Act. And that was the legislation that was sort of rushed through really in light of Russia's invasion of Ukraine. The aim of it being to make it easier for the government to impose sanctions and harder for foreign criminals to launder money through UK property. This bill, its aim is to sort of tackle economic crime and improve the transparency of corporate entities in the UK. The reforms that are being proposed in respect of Companies House seek to make it a custodian and more active gatekeeper of reliable data on companies and other corporate entities. That might involve an identity verification process for directors and others, such as general partners and persons with significant control. But one really interesting element of it is this proposed discrepancy reporting obligation. As accountants, you'll know you're subject to similar sort of money laundering obligations as we lawyers are. We're obliged to carry out client due diligence on new customers, and that obligation is also sort of ongoing throughout the relationship. In its current form, the bill is proposing to subject almost everyone who's carrying on a business in the United Kingdom to a level of client due diligence checks whenever they're entering into new relationships in a business sense. And what they ask really is if there's discrepancies in the information that you get as a result of your own due diligence exercise, as opposed to what's appearing at Companies House, then there's an obligation to report that. Now, it does remain to be seen. As I mentioned, it's still a bill. It's still very much going through the process, and there could be, swathes of amendments. But if this does come into effect, and if it does apply to a wide range of people throughout all businesses, that's a fairly heavy administrative burden for directors. So again, it remains to be seen what the impact of it will be when it's finalised, but it's certainly something that we just wanted to put on your radar at this stage. David mentioned the concept of ESG earlier, and I'm sure most of you will sort of be aware of it. There's a lot of talk about it at the moment. It stands for environmental, social, and governance. And it really is about how your business impacts on society, the environment, and how robust your governance structures are. The CBI actually reported that 2/3 of investors take ESG into account when deciding whether or not to invest in a company. But even if you or your clients aren't looking for investment, there are other benefits that arise from a focus on ESG. Examples would be attracting new customers, attracting and retaining talent, lowering your costs, reducing risk, and there's also the reputational element of it as well. Some examples on the environmental side would be perhaps a focus on more green products and services, or adapting your manufacturing processes to make them more environmentally friendly. At a more basic level, sort of encouraging recycling and so on within your own organisations. On a social level, examples would be promoting equality and diversity within the workplace, involvement in local community projects, and a really important element is preventing abuses within the supply chain. So there's an increased focus now on modern slavery and the obligations around that, and also labour rights in the supply chain. When it comes to governance, the focus really is on transparency in your decision-making processes, and also accurate reporting to your stakeholders. So that all links back into directors' duties in that regard.
Thanks, Anna. And yeah, look, ESG again, I'm sure it's something that you're being asked to consider, and then both in your own businesses or companies that you're working in, but also if you're on the advisory side, the clients that you're advising. We're seeing in terms of tenders that you're going for, in terms of the statements you're making, and that there is an accountability there, that clients are following up, that you're not, there's no greenwashing going on, that there is a complete transparency, good set of records, and that you're sticking behind what you're saying in your tender or your green credentials. So it's relevant both for directors, obviously in terms of a compliance perspective, but it's clearly very relevant for professional services firms and businesses who are tendering in whatever walk of life they may be working in. So I think it's something that will remain on the radar. It's across so many sectors. There's increased investment in terms of private equity, etc., in Northern Ireland. And again, those funds and the lenders that sit behind it are looking at the green credentials of the businesses they're seeking to invest in. So it is an area that's just constantly moving into focus, and we don't see that changing anytime soon. Conscious of time, and I suppose this is a huge topic. Directors' duties, but we thought it might actually be helpful, not strictly directors' duties, but sort of areas that directors need to be considering, or else potentially they're not fulfilling their duties correctly or fully. So I think there's some topics up there on the screen. I think as Anna alluded to, a lot of the queries we're getting are probably focused around where from an individual director as opposed to company clients. But individual directors are really focused on the ever-increasing regulatory environment. So, every year there are more and more obligations that need to be complied with. And I think the key points are those that really create personal liability. So that there's contract, bribery and corruption, so that the Bribery Act compliance would impose personal liability on directors. The few we have up here, cybersecurity, be aware. I think directors have to be asking the right questions at meetings. You don't have to know the answer. You don't have to become a cybersecurity expert, but you need to know what the policy is, what the process is. Do you have insurance in place? And if there's a cyber attack on your business around ransomware, etc., there is a lot going on behind the scenes around that in terms of hacking and businesses, local businesses being victims of that, and having appropriate measures and policies, insurance policies, etc., in place are really key. Data protection is another one that's been talked ad nauseum in terms of GDPR, etc., but it remains on the radar. It remains something that directors should be interrogating in terms of their own business. Hasn't gone away. The obvious ones we've discussed around insolvency, zones of insolvency, financial performance. I think the other two on this slide look back at COVID support measures. So again, this is an area where if investors are looking at a business, they'll be looking at the actions and directors and boards took during the COVID period. And there's very much a sharp focus on grants obtained, furlough, how furlough was applied, how payments were calculated, records that were submitted to HMRC, etc. So there is a real focus on that from a due diligence and a compliance perspective, looking back, and little sympathy on the part of investors for any mistakes that may have cropped up during what was a very difficult time for all businesses and all professional advisors. And then the sort of last one there was just the M&A funding market. It's just for directors to be aware of what the market looks like, to be aware of opportunities, to be aware of the questions that might be asked, the areas that are becoming and moving into focus a bit like the COVID support measures, a bit like your data protection. Are you registered with the ICO? Do you need to be registered? What personal information are you processing? What are your disaster recovery programs? In addition to what then you'd more typically expect the areas of concern to be. So it's about being aware of that wider market, the availability of credit, what that looks like, what questions are going to be asked, because unless you're on top of some of the areas that indirectly flow into directors' duties, some of the areas that will give rise to personal liability, then you're arguably not running your business correctly. And if you're not running your business correctly, getting funding, or if you're sort of in the sort of investment phase, growth phase, getting new investment on board will be very difficult. So we thought a bit of a snapshot there of a really wide range of things for businesses to consider and recent developments. But I think hopefully you'll find that useful. We're obviously happy to take any of those areas individually and discuss in more detail, but felt it was important to both give the directors' duties framework, but also other I suppose topics and issues that directors and boards are approaching us on to advise. And we're happy to take any questions that may have popped into the chat, or happy to take any new questions now if people have time. I think we ran over a little bit, but
we have a few questions in, so thanks very much, David and Anna. It is absolutely a wide-ranging topic, and actually one that you really need to consider before getting yourself appointed as an executive director, never mind the other banners of directorship that you can quite easily get caught under. So one question we have is around risk assessments and their ability to, I suppose, as a board to address risks, including the likes of insolvency risk, which you did mention. Is this something that you would recommend that companies and as a board that they should undertake in terms of performing these risk assessments, and how often, if so, how often should they be done and reviewed, for example?
Yeah, I'm happy to take that. Yeah, absolutely. It's something companies should be doing. I suppose it depends on the particular risk that you're assessing as to how regular it should be done. If it's health and safety, there will be requirements as to how regular those assessments need to be done. If it's more, financial cash flow, looking at projections, looking at financial standing around solvency, etc., then I think that needs to be, depending on your position, that could need to be weekly or monthly, depending on how the business is performing. But absolutely, it's something that the company should be doing. I think from a director's duties perspective, it would be making sure that the fact that those assessments are being carried out and undertaken is documented. So that if for whatever reason it was challenged in the future, that there's a very clear record of the steps taken, why the steps were taken. If it's something that is outside of the directors' reasonable areas of expertise, again, they should probably be speaking to experts such as the people on this call, and other areas as well, to get expert advice. As we said before, directors shouldn't follow that advice blindly, because unless you're actually running the business, you don't know the exact situation. But again, it's about making sure you've taken the right advice, you've done the risk assessment, and then you've followed up and it put into place that advice following your independent assessment of it. So probably be different depending on the risk, but absolutely it's something that directors and boards should be doing, both because it's good practice, but also because it is showing that you are complying with your duties and you're sort of behaving, you're interrogating your own business.
Yeah, I think at least important to have it on the agenda, so it's front of mind in terms of something that should be done at the appropriate time, whereas it's quite hard often to get things on the agenda in the first place. Another one then, kind of conscious that we are here presenting to a bunch of chartered accountants, and we will all either in our direct job capacity maybe be directors in companies already, or acting in the other sort of shadow director, de facto director roles, or indeed on a voluntary capacity, which I suppose from my own experience can often be a worse position, operating on boards, be that on charities or on other companies. Is there a sense that the obligations for a chartered accountant on a board can be more?
Yeah, I'm happy to take this one. So I think it goes back to what David mentioned about there being sort of two limbs to consider when you're trying to ascertain the threshold and the level of duty that will apply to a director. There is the standard sort of what a director, a general director would be held to, but the courts will take into consideration that particular director's skills and qualifications. So that would go to, you know, a chartered accountant. There would be a level of expertise in and around that area expected of them. Similarly, and if it was, for example, a solicitor on the board as well, we would be expected to know the legal side of things. It is that two-limb test, your objective and your subjective. So certainly if it was a matter that related to a chartered accountant's experience, they would be held to a higher level than someone who has no particular experience in those sort of matters.
Yeah, I just reiterate the point that it depends on the subject matter ahead of the board. So if it's a financial matter, yes. If it's a health and safety matter, you know, that wouldn't typically be sort of part of your area of expertise. So depends on the matter, but yes, there is scope to be held to a higher standard.
I did fear that was the case when I tend to get the finance questions on any of the boards that I'm on. Another question that has come in is around, I suppose, directors' personal responsibility or personal liability when it comes to company debt. So when is a director personally liable for company debt, or how does that? Is there any crossover there?
Yeah, so typically they're not. Again, it'll depend on, you know, if it's an insolvent situation, have dividends been paid to the director when they shouldn't have been, have loans been taken out by the director from the business when it clearly couldn't afford it, etc. But assuming all of that is in order, and the company has borrowed, typically a director would not be liable because the company has its own legal personality. I think the one sort of area to obviously be aware of is if there's a personal guarantee involved. You know, I think, you know, in Northern Ireland, it's an SME market. A lot of people are directors and shareholders of various hats on in relation to their business. So quite often you would find that there is a liability there in respect of the company's debts, but it's not because they're a director. It's simply because that's the commercial arrangement that's been struck with the lender. Yeah.
Okay. And then the last question that we have, unless any others come in, is one around being removed as a director. So can you be removed as a director without the director's prior consent?
Short answer, yes, you can. I think it's important to check behind the scenes. What do the company's articles say? What do the shareholders' agreement say about the process in and around that? But there's a statutory process that needs to be followed. If the shareholders, for example, decided that they wanted to remove a director from the board, they can do so. And there's a very specific sort of procedural element that needs to be followed in and around that. But yes, directors can be removed from the board without their consent.
Okay, thank you very much. Hold on, we have another question in, and it's again on directors' personal liability. If a company is wound up or owing money, does liability extend to the director? I suspect it's maybe getting into that area of personal guarantee again, but
it's similar to the response before. So if there's a contractual arrangement like a guarantee, potentially, I think the other areas to look at will be sort of antecedent transactions, any transactions in the previous 2 years, and whether there was an intention to put assets or money or value beyond the reach of creditors intentionally. So everything's always subject to that kind of caveat, but on the assumption that, you know, the business has been run properly, that there wasn't sort of it didn't trade too long. You know, we go back to that Sequana case where there's a discussion: is insolvency inevitable, or is it a real risk, or what's the timeline? But on the assumption all those boxes are ticked, then there shouldn't be a personal liability on the part of the directors. And again, that point about record keeping, risk assessment, speaking to experts, the more you have in your corner to point to as evidence of a well-run business, then the less likely any personal comeback or personal liability is such a much more remote.
Yeah, and I think in all of this, it's just being always mindful of your duties and ensuring that, you know, in the absence of a crystal ball for any of these scenarios, but you are actually making decisions at the right time with the right information to the best of your knowledge and belief, and it's all well intended, I guess. Look, that's the end of our questions, and that's the end of our presentation for today, almost bang on time. Thank you very much again, David and Anna, for joining us, and indeed to A&L Goodbody for your continued sponsorship of this legal series. Thanks too for all of those who have attended today in such large numbers. We really appreciate it, and we appreciate the interaction with questions, because I think that really does bring it to life for everybody. As usual, you should get a request for feedback after today's webinar. Would really encourage you to complete that. We are keen to be always appealing to our members, and if there's anything else that we could be doing, then please do add it to the feedback forms. Obviously, if you absolutely loved it, we really want to hear that too, so that's good. We will have other events coming up, both in this series and in others, so do look out for the Chartered Accountants Ulster Society emails coming through with a list of our events, or indeed follow our events page online. So have a good rest of your day. Thanks again for attending, and I'll see you all again soon.